As to confidentiality of the fee agreements, I think in my experience, I've been in private practice over 20 years, and in that 20-year period, I've worked for as outside private counsel for cities, counties, and the state. And typically, most of the municipalities have pretty standard pro forma agreements. So it's just fill in the blank, with the name of the law firm and what the fee agreement. So maybe putting that online isn't such a shocking revelation. In some instances, there are some fee agreements I'm sure lawyers wouldn't rather see online, but I think typically the outside counsel arrangements are usually a state or municipal form that's used by the entity. Lastly, on contingency fees, sure, they can be higher than your normal hourly rates, and that is the risk that's built into a contingency fee arrangement. But I've seen in private practice where lawyers may get a case on a contingency or hourly blend where it's a contingency rate of, say, 33%, but the hourly rate is not to exceed X dollars per hour. And I think that would be a preferable arrangement I would like to see the state AGs enter into, so that you don't have these lawyers walking away with fees in excess of $1,000, which I think is clearly just too much money. Did I get everything?
Yes, got all. Thank you. Okay.
Jan, I
Yeah.
can handle it here. I can never let it hear me. I had just two comments. One, a correction for Peter. Cigarette smoking is not only pathetic, disgusting, and expensive, it's also unhealthy. And your comment was that that cigarette is causing an expense to government. Well, in fact, the opposite is true. As a result of it being unhealthy, it means that these people are dying sooner, which means we have less healthcare expense. And France has this problem, and they have such a strong healthcare program, and they also are trying to combat smoking. It turns out that they can't afford it. They want people to smoke more so that they won't have to continue to take care of them in their old age. They'll die sooner. So actually, cigarette smoking is actually, the more you smoke, generally, the sooner you die, and that means you have less medical expenses overall, which means the government wants you to smoke. And that's one of the reasons, I guess, why Congress subsidizes tobacco farmers. I'm kidding.
Well, how is it, that's an interesting analysis, and it's very interesting, but now, if that's the case, why were any damages paid at all?
Say again?
If that's the case, why were state governments entitled to any damages from the tobacco companies?
Let me go on. That was my comment. Of course, I'm not going to try to answer that question. But let me go on to the next one.
Logically, if you're right, then there's...
Yes, of course. Who says logic has anything to do with this? The second one was to emphasize your comments about the attorney-client. Who's the client here? And I think it's interesting because as a lawyer, and the state attorney general is a lawyer, right? He has an ethical duty to keep his client informed. At the same time, he has a duty to protect attorney-client privilege. And so if his client is the people, then he has a duty to keep him informed. If he's saying, well, no, it's not the people, it's this mythical, armless, headless, legless entity called the state, then who he or she is representing as a client, then he or she has a duty to keep that attorney-client privilege. But then it's interesting because the attorney-client privilege is the strongest privilege that we have in the legal system, American jurisprudence, as far as I know. But it's also the most brittle. And that, for example, here in the city of San Diego, we have a number of city council members who have their own separate clients. And the city of San Diego taxpayers are paying for these city council members' attorneys to protect them against these charges or allegations that are brought forth by Jan's good buddy Mike Aguirre. And I followed this up. It's very interesting because in order for them to get their attorney's fees paid for, they presented the attorney-client agreement to the city manager. The city manager reviewed it and okayed it. But the city manager at that time wasn't an attorney. Well, he was a person who had to authorize it, but he's not an attorney. So how does the attorney-client privilege between the attorneys and the city council members extend to the city manager? I don't think it does. The city manager is not an attorney, doesn't work for the attorney, so it doesn't fall under the one of the attorney staff members, doesn't work, doesn't represent, or doesn't speak for the city council members. He's a third party.
Let me just ask briefly, would it be comparable to an insurance company where there's a defense and they're looking at it? I mean, anybody care to comment on that? Okay, no.
In conclusion, my point is that when they talk about confidentiality, you say confidentiality, you didn't say privileged, which I thought was interesting, and I don't know what confidentiality means in this context. And the second thing is that the attorney-client privilege is brittle. So when you're talking about a large organization, whether it is the state of California, whether it's the people as clients, or if you're talking about the state attorney general's office, which has lots of people, or their outside counsel, you're talking about a lot of people, and somewhere along the line, it's likely that that attorney-client privilege has been breached, has been waived because it was shared, the information was shared with somebody who doesn't fall under the attorney or the client.
That's a risk. Let me just ask a show of hands, how many have questions? Okay, then I'm going to ask, we have about 5 minutes, I'm going to ask that you have narrow, pinpoint questions and have short answers so we can get these in.
My question for the panel is actually a 5th C, case selection. Should the legislature make guidelines for the Attorney General? How should the Attorney General pick the cases that they litigate?
Well, as an independently elected person in California, I guess they have some broad discretion of which cases they pursue. But again, I think if they stray too far from what might be deemed by others to be too far from core Attorney General functions, they run the risk of being slapped in the budgetary process. I guess that's one answer.
Who can overrule the Attorney General's decision?
I don't think anyone
I
can.
don't think anyone
but
can.
I go back to the premise and go
Maybe
back.
me? No. No, I'm saying maybe the judge, but is there...
Yeah, Attorney Generals can be recalled. The people can...
Bob, you had something you want?
I was just going to say it's a great question by Adam, and I think I'm a little bit traditionalist here in that I think that the better course of action is for the private sector to litigate these, what I call consumer class actions, not the Attorney General's office. But right now there isn't real clarity on how these cases get selected, and it is somewhat up to the discretion of the sitting Attorney General.